In this lecture, we shall discuss the procedure for drafting an application for an order to renew writ of summons pursuant to Order 209 of the High Court Civil Procedure Rules 2004 CI 47. The procedure for drafting an application for an order to renew writ of summons pursuant to Order 209 of CI 47. Now, there are a few points to note before we begin the drafting of this application. The first point to note is under Order 209 of the CI 47. Order 209 Sub-Rule 1 provides that for the purpose of service, a writ other than a concurrent writ shall be valid in the first instance for 12 months, beginning with the dates of its issue. It means that once a writ of summons has been issued, for the purpose of service, it shall be valid in the first instance for 12 months. What happens if the writ has not been served within 12 months? Now, Order 209, Sub-Rule 2, provides that where there's an action and the writ has not been served on the defendants within 12 months after its issuance, where a writ has not been served on the defendants within 12 months after its issuance, the court may by order extend its validity from time to time for a period as may be specified in the order, not exceeding 12 months at a time. It means that if the writ is not served within 1 year, within 12 months, you can apply to the court for the court to extend the validity of the writ of summons. What should be in the affidavits? Order 209 Sub-Rule 3 gives us some information to that effect. So Order 209 Rule 9 Sub-Rule 3 has language to the effect that an application shall be supported by an affidavit showing all the circumstances relied on, including the dates of the issue of the original writ, and also a full explanation as to why it has not been served. So bear in mind these critical pieces of information as we begin the drafting of the application. Remember, the writ is valid for 1 year. The court also has the power to extend the validity. But when they extend the validity, it shall not exceed 1 year. And when they are extending the validity, bear in mind, you must, in your affidavit, demonstrate why you were not able to serve the writ when it was first issued. So we can begin with the drafting. And these pieces of information will inform what goes into our drafts. Now, because it has not been served, remember you have your parties here. You have your parties here in the Superior Court of Judicature, in the High Court of Justice, Greater Accra, AD 2023. You have your suit number, you have your parties. But it's plaintiff applicant. Plaintiff applicant because the plaintiff is the one applying to renew the writ of summons. Why is it only defendant and there's no respondent? Think about it. You have not even said the defendant. So you can't go on notice. So it's going to be ex parte. If it's ex parte, the defendant is not going to be aware to even say that he's come to even oppose the application or otherwise. Let me make this Kenbu Accra Central. Right. Now the application, the heading, motion ex parte for leave to renew writ of summons pursuant to Order 209 of CI 47. Straightforward. Motion paper, simple motion. Motion ex parte by Joktola Esquire, lawyer for and on behalf of the plaintiff applicant herein, praying for leave to renew the writ of summons filed on the 1st of July issued on the 1st of July 2019 upon the grounds contained in the supporting affidavit, and for any further orders as this honorable court shall deem fit. Court to be moved on so and so day at 9 o'clock in the forenoon or so soon thereafter, as counsel for the plaintiff applicant can be heard. Dated Atola and Associates, this 28th day of January 2023. Remember, the lawyer will sign. And remember, your address to the registrar. But don't go and write in for copy of service because it's ex parte, so you don't have to serve any defendants. Now let's go to the application. Same title, plaintiff applicant, same title. Now the affidavits. Affidavit of Onuyaya in support. Before you begin drafting the affidavit, bear in mind these things. That the writ is valid for 1 year. You can apply to the court for an order to extend it, but you must depose to all the circumstances, including why the writ has not already been served. We shall see these in our affidavits. I, Onuyaya, of house number 11A Ajiringan, Accra, in the Greater Accra region of the Republic of Ghana, do hereby make oath and say as follows. 1. That I am the plaintiff applicant herein. So I make it that I am the deponent herein and the plaintiff applicant in this suit. 2. That unless otherwise stated, the facts deposed to in this affidavit are within my personal knowledge and belief by virtue of my position as plaintiff in this instant matter. That at the hearing of this application, my lawyer shall seek leave of this honorable court to refer to all processes filed in this suit, as if same have been annexed to this affidavit and sworn to as exhibit. 4. That to the extent also that any of my depositions are anchored on law, then same is being made upon legal counsel I have received from my lawyers, which I verily believe same to be true. That on the 1st of July 2019, upon my instructions, my lawyers commenced the present action for the reliefs endorsed on the writ of summons. That subsequent to the commencement of the action, several attempts have been made to serve the defendant with the writ of summons, while all such attempts have proved futile. That after the last attempt to effect personal service, the defendant called me on phone and gave me an express assurance that the entire amount owed me will be paid, latest by 31st January 2020. That by reason of the express assurance I got from the defendant, I instructed my lawyers to put on hold the steps being taken to serve the defendant with the writ of summons. That sometime on or around August 2020, I chanced upon a newspaper report indicating that the defendant was in the process of selling all his assets in Ghana in order to permanently relocate from Ghana. That ever since I got knowledge of the steps being taken by the defendant, I have called the defendant several times, but all of such calls and emails have been unanswered. That after several discussions with my lawyer, I resolved to continue with the suit I commenced as far back as in July 2019, in order for me to be able to lawfully recover all the monies from the defendants. Now, you'll be wondering, why are we giving this entire narrative? Remember what we saw under Order 209 sub-rule 3. It says that when you are filing your application, your affidavit must show all the circumstances relied on, including the dates of issue of the original writ, and also a full explanation as to why it has not been saved. So the information you are given that the writ was issued on the 1st of July, because the rules require me to mention it. all this explanation I'm giving as to why we're not able to serve the writ of summons, the rules require me as far as possible to explain why we're not able to serve the writ. That's why we have given this entire narrative to show that it was because the defendant gave an assurance that he was going to pay the money. That was why we didn't go ahead to serve it. So that is an explanation, and it's because of Order 209, Sub 3. So after giving the factual basis, what do you do next? Paragraph 12. Now you've told the court that this is why you could not serve the writ. What do you do next? Paragraph 12. That I am advised by my lawyer, and I verily believe him to be true, that since the writ of summons issued on the 1st of July 2019 has not been served within a year after its issuance, same has expired. Same has expired. Or let's say the writ has expired. That I'm advised by my lawyer, and I verily believe him to be true, that since the writ of summons issued on the 1st of July 2019 has not been served within a year after its issuance, the writ has expired. Paragraph 13. That I'm further advised by my lawyer, and I verily believe him to be true, that since more than 12 months have also elapsed since the writ was issued, the writ of summons must be renewed before same can be properly served on the defendants. This information, you know, is because it's in the CR 47. So you can't just state it like that. You must show that I am advised by my lawyer, and I verily believe him to be true, that before the writ can be served, because 12 months have passed, then it must be renewed. Paragraph 14. Wherefore I pray that an order that the writ of summons filed on, issued on the 1st of July 2019 be renewed in order for same to be served on the defendants. Wherefore I pray. Sworn at Accra, this day of 2023, Deponent, Commissioner of Oaths. This is the end of the application for an order to renew writ of summons. Very simple. Bear in mind Order 209. Bear in mind what the law says. When you give the factual basis why you've not been able to serve, then all you add is that I have been advised by my lawyer, and I verily believe him to be true, that because 12 months have passed since we issued the writ, then I must renew it before I can serve it. That's all. Give the factual basis and tell the court that you have been advised by your lawyer, and you verily believe him to be true, that because the writ has expired, you must renew it before you can serve. That's what you must put over there. So take a look at the motion paper, and then take a look at the first page of the affidavits, and then the second page of the affidavits, and then the final page of the affidavits. This is the end of our lecture on renewal of writ of summons. Thank you.